Well, let's talk about that first with former federal prosecutor and legal analyst Doug Burns. He joins me now. Doug, good to see you. So we wanted to bring you on today because I wanted to ask you first about whether or not that is unusual, before a pending indictment, if it does come down, for the parties to meet beforehand, face-to-face. If so, if it is not unusual, what do they talk about?
Well, it's unusual that it would be the day of the return of the indictment.
Okay.
Not to get in the weeds. Normally, you'd meet, 2-3 weeks before. You'd make your arguments, your pitches, as it were, as to why you don't think the case should be brought. I've been in many of these meetings on both sides, as a prosecutor, as a defense lawyer. And then, of course, the government might call with the bad news, very calm. We've considered all your arguments, but unfortunately, we're going forward with the case, et cetera, et cetera. Today is a mishmash of a lot of moving parts, because I just learned literally minutes ago that they've added a count to the classified documents case in what we lawyers call a superseding indictment, Andrew. So they might have been in there talking about that. Again, I keep harping on the fact that, the day-to-day practice of federal criminal law and the day-to-day cases are different than these political cases, because we engage in all these meetings and everything, and nobody's, following it or reporting it in the media, et cetera, et cetera. So again, my weak answer to your question is they were probably meeting about the superseding indictment, adding the new count, and then they were probably meeting about the January 6th case, although it sounds to me, just reading tea leaves, that the Department of Justice has decided that they are, in fact, going forward with that case.
Yeah, and Doug, you kind of got ahead of me there. We do want to talk about that. There are major changes that were just reported on in the classified documents probe there, also that is coming from Jack Smith's team as well. But on the January 6th probe and the question of what that indictment might look like for the former president, it would be his third indictment this summer. That is unprecedented and very, very historic. If it does, in fact, come down, he said as much last Tuesday that he got a target letter saying that essentially, he is a target of the investigation, and Trump expects he will be indicted and arrested over January 6th. Since you and I last spoke about January 6th, have you seen in the interim any, elucidation or inference about what charges Jack Smith could be preparing against Trump in relation to January 6th? Or do we just have to wait to read the indictment?
A little of both.
Okay.
A, you have to wait, but B, in today's media world where you guys get very good information often, the reporting was pretty straightforward that they were going to be looking at a count of conspiracy to defraud the United States, a count of some type of deprivation of rights under color of law, like a civil rights concept, and then some type of obstruction of justice charge. So assuming that that's accurate, that's sort of what you're potentially looking at. But the reason why both are right is, having finished up my point about the three different prongs, we have to wait and look at the indictment. Because remember, this is important. A lot of pundits went on the air saying that they felt that the classified documents case was weak. That's kind of a no-no, because it violates the rule you just set up right now, which is let's wait and see what it says. And when the classified documents indictment came out, it was a lot stronger than people expected. So again, It could be the same thing here. We have to just wait and see what it says.
Yeah, I mean, do you anticipate an indictment coming this weekend? I mean, do indictments from federal court come on the weekend? That was one of the questions a lot of us had in the newsroom, because the grand jury did meet today. Then we got word that no indictment was coming down. And so this is all tied to whether or not the grand jury is meeting, and then they would vote on it, presumably. That's how this all happens?
Well, here's a little... not inside baseball, but just nuts and bolts. I mean, basically what happens is, as a federal prosecutor, you go in the grand jury and you present evidence. Then there comes a point in time when you say, ladies and gentlemen, I'm going to return Monday and I'm going to ask you to vote on the proposed indictment. We're going to read it to you. So they read the indictment, and then the assistant U.S. attorney, me in my example, steps outside the room, and they get a knock. Okay, we've voted, we've returned a true bill. Here comes the interesting part. The correct terminology is that an indictment is handed up, not handed down. Why? Because at the end of the day, an assistant U.S. attorney however many indictments there are, and literally hands them up to a judge who is on that supervisory grand jury duty. Then the judge says, quote, I find that these indictments are in order, and I direct you to file them in the clerk's office. Then you go to the clerk's office, and they're assigned a number, rolling numbers throughout the year, 752, 753, 754. Okay. Later in the year, obviously the number's higher. That's how the process works. So here, it seems unlikely that they voted on anything today. They may vote on it tomorrow. And to answer your question about the weekend, it's generally you do not see indictments handed up or returned on weekends, generally. But, the court could open for a particular day, but I doubt it.
All right. I know I just want to kind of transition from the other Jack Smith case as well there, January 6th, to the classified documents case, Doug, while we have you, because before we set up this interview, news came down about that particular case they are trying to prosecute, so much so that they have added charges against the former president, and they have now included a third defendant in the indictment as well. I want to put up this tweet from Fox producer Sean Langiel. He says a third defendant has been named in the Trump document case, Carlos De Oliveira, who has been identified as Mar-a-Lago's head of maintenance. So what do you make about this? Did you have this on your radar that they would possibly add another defendant? Now it's Donald Trump, Walt Nauta, and Carlos De Oliveira. He's the head of maintenance at Mar-a-Lago. And I want to read from the superseding indictment, Doug, a part that I think is quite interesting, and so do all of us here in the newsroom. It goes as follows. De Oliveira told Trump employee 4 that the boss, unquote, wanted the server deleted. Trump employee 4 responded that he would not know how to do that and that he did not believe that he would have the rights to do that. Trump employee 4 told De Oliveira that De Oliveira would have to reach out to another employee who was a supervisor of security for Trump's business organization. De Oliveira then insisted to Trump employee 4 that, quote unquote, the boss wanted the server deleted and asked, what are we going to do? So this individual now, Carlos De Oliveira, ensnared in this investigation, now a defendant. And so, this is quite something for, those of us like you and me who have followed this case so closely. I didn't expect yet another person, an employee staff at Mar-a-Lago, nonetheless, to be swept up into this.
Yeah, I didn't mean to jump ahead of you with that, but I found out about it 10 minutes ago myself.
No, please.
But the point is, we see superseding indictments, all the time. It's fine-tuning, finer point on the pencil, et cetera. But what's fascinating here is whether or not this last individual is cooperating with the government. I don't have a definitive answer on that, but very often DOJ will put somebody in the caption of the case when they are in fact cooperating. But to break down the significance of this is key, because you remember a lot of legal experts had no compunction about saying that the tape that they had of the former president was actually pretty strong, where he said, this isn't declassified. I put this new information right along with that. In other words, the Department of Justice here is being smart. They're sitting in a conference room saying, some jurors might turn around and say, well, the man was very busy. He was trying to sort out his personal belongings from these documents and all of that. So here, these are more like smoking guns, badges of fraud type of thing, which is, delete some type of video footage. If that witness is credible on something like that, that's very strong evidence, obviously, because it shows that he's trying to, remove evidence of wrongdoing. It's precisely that type of information that is the key distinction between just he's in possession of this stuff, he has boxes in his houses. Defense lawyers like me, former prosecutors, are going to jump up and say, wait a minute. The guy is incredibly busy. He doesn't pack his own boxes. He's trying to sort out his stuff. But today's information is the type of thing that can counter that very effectively. Seriously, Andrew.
Yeah, Doug, I should have been a little clearer contextually speaking about, what the server I was referring to in the indictment. It is about camera footage being stored on that, surveillance video camera footage around
camera,
Mar-a-Lago, around Mar-a-Lago, but also around where these classified documents were stored. And so the indictment alleges that De Oliveira told an employee of the Trump organization or the Trump campaign or what have you that the boss wanted the server deleted. Also, that Walt Nauta wanted De Oliveira to talk to that same Trump employee to see how long camera footage was stored. So this is all very, very interesting. You know, this happened today, Doug, but also let's get into the superseding indictment against the former president. More charges of willful retention of documents and obstruction. At least that's what we're being told. That was in this superseding indictment, and we've read some of it. But you said superseding indictments are quite common. Did you expect, though, that they wouldn't be done with their case, that they would add more charges against the former president in the documents probe? What is Jack Smith doing here? Why did they have the goods initially? Or did they learn more information?
Yeah, I would not have expected it in this type of political case for the exact reason you just said, which is, you know, you would have thought that they would have dotted the I's and crossed the T's. You know, don't forget, this is a man, and I'm not criticizing him, but this is a guy doing one case, okay? You know, most assistant U.S. attorneys like me were doing 40 cases at a time. So the point is, you would have thought that he would have been finished. But again, I can't begrudge him. He claims he's got new evidence. It sounds to me like they interviewed this individual. I'm just theorizing. And he provided very, very helpful information, to wit, this thing about the camera footage. And, you know, they got him to concede that what he did was wrong, potentially, put him in the caption of the superseding indictment, and now he's a government witness. That's very, very possible. But to answer your question again, no, I would not have seen that coming. You know, again, at this point, I have to break out the political discussions and the legal ones. Legal discussion is very simple. If the government has credible evidence that somebody broke the law, and you can specifically tie it to a particular statute and prove it beyond a reasonable doubt, then you can do it all day long. Politically, as I've told you previously, it's rare in a white-collar type of case, like a documents case, to turn around and bring a second indictment. Okay. Usually there'll be coordination, and they'll say, okay, hold your case in abeyance as an insurance policy if something goes wrong in our first case, particularly, by the way, in cases that aren't violence or narcotics or organized crime. But the point is, again, in this incredibly toxic world, and I keep coming back to that, right away it sounds like, oh, how can this man Burns be defending him? I'm not defending anything. I'm just telling you that in the real world, day to day, they don't bring re-prosecutions and double cases. They do supersede all the time, in fairness. So I'm calling balls and strikes the best I can. Yeah. But the fact of the matter is, they really are piling on the guy. I mean, beyond belief. It's insane. Because I've never seen a case where anybody was indicted 3 and 4 times in 38 years.
Wow. So Doug, I just want to ask, though, as well, because remember last week we brought you on Judge Eileen Cannon down there in Florida. You know, the parties agreed. She set the date for the trial in this classified documents case for next May. And so now today we're learning more charges have been filed in the indictment against Trump. What does that do to the date of the trial? Anything?
Well, that's a very perceptive point, which I hadn't thought of because I'm only 10 minutes into this news. This is almost undoubtedly going to cause another adjournment, okay? In my view, I have said previously, I'll just keep repeating it, and then I'm going to have you take out the tape and play it, as I jokingly told you, that I don't think the case is going to be tried before the election. People can call me crazy, maybe I am, but I don't think this case will be tried before the presidential election.
All right, Doug Burns, as always, we do appreciate your legal mind into these major stories, especially regarding former President Donald Trump. Some big developments today in both the January 6th probe and the classified documents probe, and we'll definitely be speaking again. Thanks so much.
My pleasure. Thank you.